Everyone settle in, roll cameras, and action! I want full steam from the locomotive as it crosses the bridge.
The rabbit breeder case that broke the legal system. What happens when a minor dispute between rabbit breeders goes too far? Discover the Gatekeeper Protocol and how the Supreme Court uses Rule 5A to block meritless appeals. In this video, we analyze the landmark procedural battle of Sachs v. McMillan. What started as a Harassment Act claim between two New Zealand rabbit breeders evolved into a years-long campaign of omnibus applications and relentless filings. We break down the critical legal filters that protect our justice system. The District Court Dismissal, why the initial case was labeled frivolous and vexatious, the Senior Courts Act 2016, understanding Section 68B and the absolute jurisdictional bar on certain appeals, Rule 5A and the Registrar, how the Supreme Court stops abusive filings before they even reach a judge's desk, Section 164C, the nuclear option that can ban a litigant from filing for up to 3 years.
Many litigants believe that with enough persistence and a stack of paperwork, they can force the legal system to give them a final word from the highest court in the land. In reality, the Supreme Court of New Zealand is protected by a series of strict jurisdictional filters designed to keep the docket focused on matters of genuine public importance. The case of Sachs v. McMillan tested these filters to their limit. It started as a minor dispute under the Harassment Act between two rabbit breeders, which a district court judge dismissed as frivolous and vexatious. Rather than accepting the dismissal, the applicant began a campaign of relentless filing, attempting to move the argument through every tier of the judicial hierarchy. This case highlights a critical systemic necessity. If an apex court cannot immediately identify and stop meritless, hyper-persistent disputes, the entire justice system risks being overwhelmed by the sheer volume of frivolous appeals. The escalation first stalled at the High Court. The applicant's appeal was deemed abandoned after she was refused a waiver for security for costs. She then moved to the Court of Appeal, where her application for leave was denied. The court found there was no arguable question of law for them to consider. The applicant responded by flooding the court with omnibus applications, demanding everything from a recall of the judgment to name suppression. By August 2025, the Court of Appeal reached its limit. Justice Cook refused to accept further filings, noting the court had fulfilled its role and no longer held jurisdiction over the matter. Undeterred, the applicant filed for a final review in the Supreme Court, seeking to overturn every previous decision made by the Court of Appeal. This relentless upward pressure creates the ultimate test for the court's statutory gatekeeping, the absolute rules that determine what the Supreme Court is legally allowed to hear. The application was stopped at the threshold. The Supreme Court Registrar refused the filing immediately, long before it could ever reach a judge's desk. Rule 5A of the Supreme Court Rules 2004 mandates the Registrar reject applications plainly outside the court's jurisdiction. This enforces the Senior Courts Act 2016. Specifically, Section 68B dictates the Supreme Court has zero jurisdiction to hear appeals against a refusal to grant leave. When the Court of Appeal denies leave, the legal pathway reaches its statutory end. Under the Senior Courts Act, the Supreme Court lacks the legal authority to revisit that decision. The applicant attempted a tactical workaround to bypass this limit. She tried to recharacterize her denied appeal as a completely different type of challenge. She asked the Court of Appeal to recall their refusal. When declined, she appealed that secondary denial to the Supreme Court as a new matter. On paper, there is a narrow exception. Section 74(4) of the Act, as discussed in Ray v. Commissioner of Police, does allow the Supreme Court to hear appeals against certain recall judgments. However, the Ray exception only applies to substantive decisions, judgments that deal with the core facts of a case, rather than procedural disagreements about whether an appeal should be allowed. Justice Williams rejected this maneuver. Because the underlying issue was a refusal of leave, the jurisdictional bar in Section 68B remained absolute. This reinforces the anti-evasion principle. The court will not allow litigants to bypass statutory limits by simply reframing or renaming a denied application. The persistence shown in this case represents a broader challenge for the legal system, litigant abuse that consumes public resources and clogs the courts for others. New legislative protections, including the 2025 Family Violence Amendments and the Senior Courts Act, now provide specific tools to defend the system against these strategies. Filing meritless omnibus applications now serves as a trigger for Section 164C of the Act. Once Section 164C is triggered, the court issues an automatic restraint order, banning the individual from making further civil filings for up to 3 years. To file anything at all, they must first secure express permission from a high court judge. Disregarding these jurisdictional limits carries a high price. The law revokes the standard privilege of filing civil claims, placing the litigant's future access to the justice system under strict judicial supervision.
This is a true collaboration between human and machine.
Hi everyone. If you like this content, press the like button, the subscribe button, and follow for good content.
Elevate your perspective.